a big victory for the Hindu side. Do first give us your first reaction with regards to the particular verdict that's come out.
See, I think the judgment passed by the Honorable Allahabad High Court is well reasoned, and ultimately our arguments and submissions before the High Court were that there is no infirmity in the order passed by the District Court of Varanasi on 17th of January and 31st of January, because we have ample proof and evidence to prove and show that the puja which was happening in the cellar of Vyas Parivar was happening till November-December 1993, wherein without any written order this puja was stopped, and therefore the Honorable District Court of Varanasi was right and in exercise of his powers under Order 40 of the CPC has given this direction for starting of puja and worship. So this order is perfectly valid, and all the provisions of CPC have been followed in passing this order. So this arguments were made before the Honorable Allahabad High Court, and today the Honorable Allahabad High Court has dismissed the first appeal from order petition of Anjuman Intezamia, both the petitions which were challenging two orders of 17 January and 31st of January.
Right, Mr. Vishnu Shankar Jain. Do also tell us this, that at this point we know, as Mr. Hari Shankar Jain also said, that you are planning to file a caveat to the Supreme Court just as a precautionary measure.
Yes.
If you could take us through that as well.
Yes, definitely we'll file our caveat before the Honorable Supreme Court, and we are thoroughly prepared because we have conducted the matter in the lower court and the High Court. So if they approach the Supreme Court, we will make our submissions before the Honorable Supreme Court.
Right, Mr. Jain. So, Mr. Jain, while the Allahabad High Court has come out to say that there is no merit in the plea filed by the Muslim side, what are you expecting will be the next steps that the Muslim side is going to take against this particular judgment that's come out?
See, I cannot expect anything until unless they take their legal remedies, because I am the counsel for the plaintiffs, so I cannot predict what they will do. But whatever eventuality will happen, so far as legal part is concerned, we are completely prepared and will respond in the court of law.
Right, Mr. Jain. Mr. Jain, also if we could just go back to the Varanasi High Court's judgment that had come, the evidence that, as you said, that you are well prepared with all the evidence that's there. If you could just quickly sum it up for us, just for our viewers to get context.
See, we have court orders from 1800 and in 1850, in 1888, in 1901, wherein it shows, the court order shows that Vyas Parivar was in possession of that Tehkhana, and there is a map also in Deen Mohammed case where it is shown as Vyas Parivar Tehkhana in the map filed by the British government in 1936. Apart from that, recently also we have filed documents under section 107 of the CPC, wherein from 2013 till 2023, the Navahan part, which is the Ramayan part, Akhand Ramayan part, was happening in the Vyas Parivar Tehkhana. So all these documents were filed before the Honorable Court, which shows that Vyas Parivar was doing puja in that premises. So this entire theory that this is a part of a mosque and this is a mosque premise is completely erroneous, because the historical documents, the legal documents, the evidences which are there on record prove and suggest that this was the Tehkhana which was owned by the Vyas Parivar, and therefore there is no prejudice which is caused to the Anjuman Intezamia if that puja and worship is allowed in that Tehkhana.
Well, Vishnu, first of all, very good afternoon to you, good morning to you. And, a very, very important order has now come in from the Allahabad High Court. But if I was reading this particular judgment, and I'm sure you too were reading that, almost a 54-page order, a very extensive argument was rendered by the Muslim side with regards to, all of this being a res judicata. So, how do you see that whole argument being turned down by the court saying that, such an argument to the Muslim side cannot be taught? If you could explain to our viewers in a little detail.
See, res judicata is not a bar which will apply in this case, and let me explain you. The Anjuman Intezamia has said that the judgment passed by Deen Mohammed case of 1936 and upheld by the Allahabad High Court in 1942 is a res judicata, and the court cannot reverse that judgment because there is already a finding passed by the British court in that era. So we had countered that argument on the point and on the footing that in Deen Mohammed case, no Hindus were parties in that case. It was a case fought between the British government and Deen Mohammed in his individual capacity. The provisions of Order 1 Rule 8 CPC, which is like a suit of a representative capacity, like for example, to explain my thing by way of an example, in Ram Mandir judgment, even if anyone is not a party, it is binding on that one, because it was a proceeding under Order 1 Rule 8, it's a representative suit. So Deen Mohammed was not a representative suit, and it is not binding on the Vyas Parivar or on the Hindu parties, and therefore that's the segregation which we tried to make before the Honorable Court, which has found favor with the Honorable Court.
Vishnu, when we were attending the hearing, we saw the Muslim side constantly argue that this is a place that is completely in fact, Gyanvapi is a part of the Gyanvapi Mosque, and no kind of a prayer can be allowed there. There would be a law and order situation that could erupt. All these arguments coming in, not going much into the CPC, only a bar on the Places of Worship Act being cited and the law and order situation being cited. Do you think that the Muslim side did not have a strong case and they were constantly trying to move away from the whole subject matter when it comes to the whole CPC argument, or going into the whole history of that particular report as well?
So far as law and order is concerned, let me tell you that the Advocate General for the state was present in the hearing, and the Advocate General assured the Honorable Court that law and order will be maintained by the state government. And so far as the aspects of CPC are concerned, it is very well evident, as I have enumerated here in above also, that we had ample evidence to show and prove that we were worshipping in the premises in question. And there was no infirmity in the order of 17th of January and 31st of January. The Honorable District Court of Varanasi has exercised its powers under Order 40 of the CPC, wherein the power is there to appoint a receiver, and the court can direct the receiver to conduct and perform a particular duty. So it is the power of the Honorable Court. The Honorable District Court of Varanasi has exercised its power, and there is no erroneous part in the order. So that's why the Honorable Allahabad High Court has dismissed both the petitions filed by Anjuman Intezamia.
Last and final question before I let you go. There was a constant argument by the Muslim side that if at all this particular prayer for puja is allowed in this particular suit, then this would be completely allowing that whole suit. This interlocutory prayer is like a final prayer that is being granted. How has the court dealt with that, and how you had countered that submission when the hearing had actually happened?
See that all the arguments are mentioned in the judgment. The final prayer and the interim prayers are different. If you will read the interim relief, it's a direction to the district magistrate to perform, to organize so that the Kashi Vishnu Trust priests can do the puja. So these are the orders passed under section 13 and 14 of the Kashi Vishnu Trust Act. So far as the petitioner plaintiff Shailendra Pathak is concerned, he has not been granted the right to conduct puja as of now. The puja is being conducted by Kashi Vishnu Trust. So the interim relief and final relief are completely different. We had pointed out before the Honorable Court, and that's also taken care and taken as a part of judgment. It's mentioned in the judgment.